This is fifth part of fundamental rights and fundamental duties in the series of our Constitution. By virtue of this power, Parliament enacted the Public Employment Requirement as to Residence Act 1957, empowering the Government of India to prescribe residence as condition for employment in certain posts and services in the state of Andhra Pradesh and in the Union Territories of Himachal Pradesh, Manipur and Tripura. This act having expired in 1974, there is no provision to prescribe residence as a condition for public employment, except that for Andhra Pradesh special provisions have been made by inserting a new Article 371D in the Constitution itself. The state may reserve any post or appointment in favor of any backward class of citizens who, in the opinion of state, are not adequately represented in the services under the state. Article 16(4). This is to provide socio-economic equality to the disadvantaged. Offices connected with a religious or denominated institution may be reserved for members professing the particular religion or belonging to the particular denomination to which the institution relates. Article 16(5). The claims of the members of the scheduled caste and scheduled tribes shall be taken into consideration in the matter of appointment to services and posts under the Union and the states, so far as may be consistent with the maintenance of efficiency of the administration. Article 335. But the proviso to the Article 335 providing for giving relaxation in qualifying marks in any examination or lowering the standard of evaluation in favor of the members of the SC/ST hits the consideration of maintenance of efficiency in administration and has done away with the emphasis on it laid down the apex court in some cases. The Supreme Court has held that while Article 16(4) is apparently without any limitation upon the power of the reservation conferred by it, it has to be read together with Article 335, which enjoins that in taking into consideration the claims of the member of the scheduled caste and scheduled tribes in the making of appointments in connection with the affairs of the Union or a state, the policy of the state should be consistent with the maintenance of efficiency of administration. The result is that there can be no doubt that the constitution makers assumed that while making adequate reservation under Article 16(4), care would be taken not to provide for unreasonable, excessive or extravagant reservation. Therefore, like the special provision improperly made under Article 15(4), reservation made under Article 16(4) beyond the permission and legitimate limits would be liable to be challenged as a fraud on the Constitution. It is to be noted carefully that the prohibition against discrimination in the matter of public employment is attracted where the discrimination is based only on any of the grounds enumerated, namely religion, race, caste, sex, descent, place of birth or residence. It does not prevent the state, like other employers, to pick and choose from a number of candidates either for appointment or for promotion on grounds of efficiency, discipline and the like. It is also to be noted that though reservation in favor of backward classes is permissible under Clause 4 of Article 16, no such reservation is possible in favor of women, nor in any other discrimination in favor of women possible, as for example relaxation of rules of recruitment or standard of qualification or the like. For the furtherance of social equality, the Constitution provides for the abolition of the evil of untouchability, Article 17, and the provision of conferring titles by the state. A nine-judge bench of the Supreme Court has, in Indra Sahni's case, popularly known as the Mandal Commission case, laid down the following important points which summarize the law on the issue of reservations in government employment. For further discussion, authors shorter the Constitution 13th edition under Article 16.4. Article 16.4 is exhaustive of the provisions that can be made in favor of the backward classes in the matter of employment. Backward classes of citizens is not defined in the Constitution. There is an integral connection between caste, occupation, poverty, and social backwardness. In the Indian context, lower castes are treated as backwards. A caste may be itself constitute a class. The backward classes can be identified in Hindu society with reference to castes along with other criteria such as traditional occupation, poverty, place of residence, lack of education, etc. And in communities where caste is not recognized, the rest of the criteria would apply. The backwardness contemplated by Article 16.4 is mainly social. It need not to be both social and educational. Men's test signifies imposition of an income limit for the purpose of excluding persons from backward classes. Those whose income is above that limit are referred to as creamy layer income, or the extent of property can be taken as a measure of social advancement, and on that basis the creamy layer of a given caste can be excluded. For getting reservations, a class must be backward and should not be adequately represented in the services under the state. The reservations contemplated in Article 16.4 should not exceed 50%. The rule of 50% should be applied to each year. It cannot be related to the total strength of class, service, or cadre, etc. Reservation of posts under Article 16.4 is confined to initial appointment only and cannot extend to providing reservation in the matter of promotion. If the reservation in promotion exists, it shall continue for 5 years. 16th November 1997 by the Constitution 77th Amendment Act 1995. This limitation of time has been removed by inserting clause 4A to enable it to continue reservation in promotion for the scheduled caste and scheduled tribes. Identification of backward classes is subject to judicial review. It is to be noted that many states are attempting to surpass the 50% limit. All those cases are under the consideration of the Supreme Court. The vacancies reserved could be carried forward for a maximum period of 3 years if candidates from backward classes are not available, after which they were to lapse. By inserting clause 4B in Article 16 by the Constitution 81st Amendment Act 2000, the state has been empowered to consider such unfilled vacancies as a separate class to be filled up in any succeeding years or years. Article 17 of the Constitution says untouchability is abolished and its practice in any form is forbidden. The enforcement of any disability arising out of untouchability shall be an offense punishable in accordance with law. Parliament is authorized to make a law prescribing the punishment for this offense under Article 35, and in exercise of this power, Parliament has enacted the Untouchability Offences Act 1955, which has been amended and renamed in 1976 as the Protection of Civil Rights Act 1955. The word untouchability has not, however, been defined either in the Constitution or in the above act. It has been assumed that the word has a well-known connotation, primarily referring to any social practice which looks down upon certain depressed classes solely on account of their birth and disables them from having any kind of intercourse with people belonging to the so-called higher higher classes or castes. This act declares certain acts as offences when done on the ground of untouchability and prescribes the punishments therefore, as for example, refusing admission to any person to public institutions such as hospital, dispensary, educational institution, preventing any person from worshipping or offering prayers in any place of public worship, subjecting any person to any disability with regard to access to any shop, public restaurants, hotel, public entertainments, or with regard to the use of any reservoir, tap, or other source of water, road, cremation ground, or any other place where service are rendered to the public. The sweep of the act has been enlarged in 1976 by including within the offense of practicing untouchability the following: insulting a member of scheduled caste on the ground of untouchability, preaching untouchability directly or indirectly, justifying untouchability on historical, philosophical, or religious grounds, or on the ground of tradition of the caste system. The penal section has been enhanced by providing that in the case of subsequent convictions, the punishment may range from 1 to 2 years imprisonment. A person convicted of the offense of untouchability shall be disqualified for election to the union or the state legislature. If member of the scheduled caste is subjected to any such disability or discrimination, the court shall presume, unless the contrary is proved, that such act was committed on the ground of untouchability. In other words, in such cases there will be a statutory presumption of an offense having been committed under this act. The prohibition of untouchability in the Constitution has thus been given a realistic and effective shape by this act. This is all about today's part of Constitution series. Thanks, regards.